Welcome to Hull and Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popvic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull in Toronto, here are Ian and Susanna.
Hi, and welcome to Hull and Estates and Succession Planning. We are podcasting on August 25th, 2009. I'm Ian Hull, and this is my good friend Jordan Atin, who has agreed to sit in for Susanna Popvic-Montag again this week. We had a good discussion about your frantic feelings in the airport last podcast,
yes.
And one of the things you raised was this idea of how to get over a legal burden of a lost will. And I thought today we would like to talk a little bit about this whole concept of a lost will, because that's something that does happen. And what do lawyers do, and how do we fix that problem? Before we do that, I just want to remind everyone that we have a regular breakfast series on September 24th coming up. We have three great speakers. Susanna Popvic-Montag, who will be speaking on joint retainer issues. I'll be speaking on some recent case law developments and how it affects solicitors, and then our associate Megan Conley will be speaking. So it's all the information's on our webpage, so if you're interested in either coming or watching it as a webinar, which we do, please feel free to contact us or check out the details on the webpage. All right, so let's bounce back now, Jordan, if we could, and talk about, let's set the stage. The scenario is what we talked about last week, and that is we've done a will, it's well done, and it's got no errors in it, it's been signed properly, yes. But for some reason it's been lost, because, for your example, might be the client takes it home with them and they don't put it in the safety deposit box and it's lost. The person dies. And what does that mean, that they die without a will? Does it mean that we have to deal with the old will? How do we deal with it? So it's what we call in law the lost will in that scenario. So why don't we talk a little bit about that?
Sure. I mean, people often ask, can I prove I have a copy of the will? Is that good enough? Well, that's a good question. Sometimes it's good enough, and sometimes it's not. The way the law works in simple terms is that if you can't come to court with the original, then the court asks one question: where was the original last known to be? Was it in the possession of the person writing the will, the testator? If it was in their possession, then the court presumes that the testator, the will maker, ripped it up, destroyed it intentionally to revoke it. So then, if that's the situation, the court will say, you can't prove a copy, because we think that the original was deliberately destroyed and therefore revoked. And that's a pretty hard and fast rule developed by the case law for hundreds of years. Right.
If you hold your will, and that's the only evidence that exists after you die, that you were the last person holding it, it's a very tough burden to get over, this presumption that you ripped it up.
Right, exactly. Because, of course, destroying a will, intentionally destroying the will with the intention to revoke it, is a way of destroying your will and revoking your will. So that's why there's that presumption.
And then we go back to the prior will, or we have no will.
Right. And just as an aside, that's one of the reasons we only sign one original will. Mm-hmm. Because if you had, let's say you signed more than one original will, and you wanted to revoke it, so you destroyed one copy, what would the effect of that be if there was another copy? So that's why, just as an aside, why we do one will. But the idea there, so there are certain ways of getting around that burden. So let's say I've given the original will to the testator, to the will maker, yeah. And we know that there was a fire in the house, and the will maker died in the fire, and the whole house was burnt down. Then that evidence would be used to rebut the presumption that she destroyed it on purpose.
Right.
So if we can show that the will was destroyed unintentionally, or destroyed without intending to revoke it, then we're over that burden, and now we can prove a copy. And not only can we prove a copy, as you know probably better than anyone, you can prove where there isn't a copy. Can you?
Yeah, well, I mean, that's a great point. And early in my career, I had the pleasure of doing that, where we had good evidence. And in that case, it was a situation where it was last in the hands of the accountant.
Right.
And so, therefore, we didn't have the burden of the ripping up worries and that it was last in the hands of the will maker. But the accountant couldn't find it. And the accountant's recollection was what the will said, because the accountant had actually done tax planning around the parameters of this will. So the accountant's not a lawyer, but the accountant was able to say, I know that the will did the following. It appointed so-and-so as an executor. Right. It gave all of the assets to this person, and so what we did was we wrote our own will. and we went to the court, and the judge first of all looked at us like, "What are you, crazy? Right. You're writing wills for people?" This is in your handwriting. That's right, yeah. And we said, "No, that's true. It may be a bit odd, but this is the will of the deceased, and it can be proven because we know it wasn't in the last hands of the deceased. We have good evidence as to what was in it." And so we persuaded the court quite properly to agree that that's the will of the deceased. So then the estate could go on and administer what turned out to be a fairly complicated estate, and it allowed for tremendous tax savings because the gifting was all designed to this one individual. If it had gone as without a will, it would have created all sorts of new tax burdens and problems for the estate. So it was interesting. I mean, that's the most extreme. Right. Most of the time, you're going to prove a copy. Someone's going to have a photocopy. A lawyer has it in his file. You said in your last podcast that you generally keep a copy of the will, but you give the original to the client. Right. Well, we could go back to you and say, give me a copy. Right. And I'll go take that copy and prove it to the court that it wasn't ripped up by the deceased or last in their hands, more importantly.
And that's one of the reasons I keep an executed copy. So in other words, it's not originally signed, but it's a photocopy of the originally signed one. Oh. So that there's some, because some people just take a copy of an unsigned will and keep that in their file. I don't think there's going to be ever a dispute that this is not an originally signed. Nowadays, you can pretty much show whether there's an originally signed one. But it's just a so it shows that it was signed. It was in fact signed. We don't have to prove that it was signed. So that's just another thing.
And the signature is just gives a judge naturally more comfort.
Right, because the judge knows that it was actually signed rather than you saying, "Oh, I know it was signed." Yes. So that's why I keep a copy of the executed.
And it's a neat point because it's really just a mechanics thing. Because if you're going to keep a copy, you may as well keep the copy that was signed anyway.
Right. It just means that you have to make a photocopy after it's signed, as opposed to making a copy before it's signed. But
right. So it's a process question as more than anything else. So that's good. That's a good practice tip. Yeah. We try to give the odd practice tip in this. This is what we do.
Works for me.
So that's fantastic. So I just found it, I think a lot of people don't realize how important an original is. Most people think, well, it's nice to have the original, but with a will, it is vital. Yes. And it can be a big problem if you don't have the original. It means this lost will process, again, though, comes back to your last podcast, and that is, if you lose a will, we can sometimes fix it, sometimes not, but it's expensive, and it's time-consuming, and it's risky that I might not be able to pull it off. And a judge might say, you know what, that's just not enough evidence for me to accept that you've got over the hurdle. Right. And so from that perspective, we create tremendous uncertainty, absolutely more costs to the administration of the estate. So we now need to come back to your podcast, your last podcast, where you reminded us that control and custody of this document is important, and it really is. I mean, everybody has to either you suggested some suggestions at the last podcast, but people have to. It seems to me, I try to remind my clients that this isn't just another contract you've signed. You haven't just signed a lease agreement to rent a car. Right. This is a big deal. Yeah. And so take that document and treat it like it's a big deal, and put it somewhere safe and where it can be found and easily dealt with and distributed, and hopefully the original form. All right, so that's great. We appreciate you talking about the lost will concept today, and always appreciate you coming in as our special guest, Jordan Atin, and taking the time to come on to Hull and Estate Succession Planning. Again, remind everyone that our breakfast series is coming up for September 24th, and we would be pleased to have you come or jump on the internet and watch us on the topics that we're going to be talking about. Thanks very much.
Thanks, Ian.
You've been listening to Hull and Estates and Succession Planning by Ian Hall and Susanna Popvic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull and Hull podcasts or leave any questions or comments, please visit our website, hullestatemediation.com.